Hey guys, I got to ask you something now. I've seen several videos where cop watchers will walk up to the police car and put their cameras there and zoom in on the laptop, CAD or MDT or whatever you want to call it. And they zoom in on the laptop and they get the address and phone number and the person's name and all the information that the cop saw in the call. Now, I don't do that. Because to me, that's almost borderline violation of confidential information. I know people say it's public information, it's in the public. But I'm going to ask you guys something. I'm going to give you a couple. I have researched and I have looked for laws on this in the state of California. I can't really pin down the law. I've Googled everything from recording inside a police car to filming a police car to, it always just takes me back to 148G. But I'm going to give you a couple laws here, a couple things here, and ask you what you think about this. And maybe we got some attorneys out there or some law aficionados that can give us a little bit of insight to this. But I keep seeing people do that. They walk up to the police car and they start filming the computer. And to me, that's a violation because that's that cop's office. Yeah, it's in public, but that's his office and that's his office computer. I don't know. Let's look at it. So, California Penal Code section 502 says, in general, this section makes it a crime to knowingly access and without permission use, misuse, abuse, damage, contaminate, disrupt, or destroy a computer, computer system, computer network, computer service, computer data, or computer program. Depending on the particular violation, this section can support a variety of fines and imprisonment in criminal actions, as well as remedies recoverable in civil actions. And I'm just wondering, so if you knowingly access this cop's computer, even though it's in public, it's in his police car, and you walk out there while he's away from his car and film that computer, knowingly access it without permission, because that cop's not giving you permission, and get that computer data and post it on YouTube, is that a civil action that that person, whoever's name and address and phone number you just put all over YouTube, can come back and sue you for doing that? And you say, well, it's public, but that information's not public. It's in a police car, on the laptop. You're over here on the sidewalk. You walk over to do that. Would that be illegal, right? You can record the person. It's okay to record people because they're in public, I'm talking about, because they see you standing there. You got a video camera. It's not wiretapping if you have a video camera because it's to be assumed, and this is by the Supreme Court, it's to be assumed that if you have a video camera, it has an audio recording with it. Not to audio record people without their knowledge could be wiretapping. But you have a video camera, they have to, assume that that's also an audio recorder in public, so that's not wiretapping. You can beat that. But in this one where they're filming the cop's computer, I don't know, man. I don't know. There was another one I wanted to give you too. Okay, here's the other one I wanted to give you real quick. Now I'm going to go through this one. It's California Penal Code sections 630 through 638. Among other things, this law prohibits, with exceptions, electronic eavesdropping on or recording of private communications by telephone, radio, telephone, cellular radio, telephone, cable, or any other device or in any other manner. Violation can result in penalties of up to $10,000 and imprisonment in county jail or state prison for up to 1 year. Now, the thing about this, you say, well, it's not private communication. Hold on a minute. This is an eavesdropping one. Now, when you're in public and you got a video camera and you're recording people, obviously that's not eavesdropping. They can see you recording. And again, the Supreme Court has ruled that if you're video recording openly, they are to assume that you are audio recording as well. That's just automatically to be assumed. They can't, it can't be two separate devices, video, audio. If you have a video camera, the Supreme Court has said people are to assume that you also have audio. And that's in public. That's not private. That's, hey, you're in the street talking to this cop. I'm recording you. You want a private conversation? Go in your house or go to the briefing room at the station. But we're talking about a police computer laptop that's in the car. Between that cop and dispatch is a communication of the person's address, maybe driver's license number, criminal record, phone number, and you're recording that and putting it on YouTube or Facebook or Twitter. Could you be guilty then of eavesdropping under Penal Code Section 630 to 638 because you recorded a private communication between that cop and dispatch off of his laptop with any other device? And by the way, when these guys are recording these cop watchers are recording this information and then putting it on YouTube, there's also a penal code or statute for that as well, which is up here, which is California Civil Code Section 1798.29 and 1798.82. This law requires a business or government agency that owns or licenses unencrypted computerized data, like a CAD or MDT laptop, that includes personal information as defined, to notify any California resident whose unencrypted personal information was or is reasonably believed to have been acquired by an unauthorized person. The type of information that triggers the notice requirement is an individual's name plus one or more of the following: Social Security number, driver's license or California identification card number, financial account numbers, medical information, health insurance, or information collected through an automated license plate recognition system, or user ID and password or other specified credentials permitting access to online accounts. And there's some more that goes on there. But the thing is, if somebody records a police computer and gets a name and let's say a driver's license number off that computer and then puts it on YouTube, that police agency is authorized by a civil code to contact that person. And so if you're one of the ones who some cop watcher recorded your information and you see it in a video on YouTube and you go, hey, that's my phone number and driver's license. What are they doing? That's my name and address. You need to contact that police department because they should have notified you that that information was acquired by an unauthorized third person. That's right. And again, I'm just reading here. I'm not always right. I'm just giving you my theory, my thoughts, but it's based on actual. I'm basing this on active on information here. So I'm waiting to hear from all of our attorneys or attorney aficionados or what have you. I bit the inside of my mouth. But I'm waiting to hear from all of you guys, you lawyers out there, to let us know what the truth is on that. So if you're one of the cop watchers that's doing that, I would kind of tiptoe carefully until you find out if it's even legal. And if you're one of the victims, contact that police agency and go, my information was breached by a third party, an unauthorized person, and I was not notified. And I'm a California resident. What do you guys think? Let me know in the comment section below. Thank you for watching.